All right, this is just a disclaimer at the very beginning. Okay. Last speaker, 2-day conference, and this is not going to be a deal where I'm going to stand up here and talk because you'd be so mad at me by the time it got over you'd throw stuff at me. So what I want to do here is have ethics presentation to you that is a little bit more lighthearted. It's kind of fun. We'll talk about the serious stuff, but I want this to be more of a discussion. I know it's the end of the time, and so I've kind of put that in the first slide you have here. When it said arena, I thought, what is this, arena? You know, is that the rodeo arena? And so I looked it up in the dictionary, and that's what it is, an area in a Roman amphitheater for gladiatorial combats. So that's what we're doing here. And if I listen to these, some of the discussions we had, especially this afternoon a little bit, this can get kind of tough sometimes for people, so it's maybe not too far away. The other thing I want to comment on is when the Solicitor General was up here, I thought, holy cow, are you like 22 or how old are you? You know, there's two thoughts I have. One was that is just, you know, how accomplished you are. So that's remarkable. The second thing is, I've heard people talk fast before, but holy cow, is that how they train you before the Supreme Court? Talk as fast as they can? Holy cow. Like an auction. And the reason I bring that up is I had a bad reputation when I first got to be a judge because in 5 years I had 5 court reporters. The first one didn't stay with me because her marriage broke up and she moved away. The second one didn't stay with me because of the same thing. I thought, oh my gosh, I'm a homewrecker, you know, because we were working long hours and going fast. The third court reporter I had a heart attack, and during court, you know, and so I went to the hospital because I was very concerned about her. And she's laying there, and she was a really nice person, and I didn't realize she had a sense of humor until she said, "You need to slow down when you talk." I thought, gee, I'm talking to my court reporter, she's having a heart attack, and that's the first thing she says to me. So I thought I better slow down. Okay, so what I'd like to do as we're doing this is to do two things. Add some humor to the afternoon, but also add some participation. So I have a quiz after I get through this. First, I want to introduce the subject. There are water managers here, and there are lawyers here, and this little cartoon says, have you noticed ethics creeping into some of these deals lately? That's supposed to be a joke. And the reason I put this little cartoon in there was because ethics are for everybody, not just for lawyers, although we do get an hour credit for this. They're for everyone. And a couple people that were saying goodbye to me that they were leaving early because they couldn't wait to sit through this ethics thing said to me, well, we don't need those ethics, these lawyers do, but engineers don't. Well, I kind of think they do. And I think this is where lawyers can kind of lead the way a little bit because ethics are in everything that we do. And so because of that, I want you to give a quiz here. So look at those questions and circle the right answer. Which is the example of unethical conduct? I picked the last one. This is like the test they used to give us in college, okay? They're all right answers, but the last one's the best right answer, okay? And that was directed towards the law professor that put me last on the list here today. All right, so I want to give you a question that kind of introduce the topic of ethics. You're driving along your car. It's a wild, stormy night. And you pass by a bus stop, and you see 3 people waiting there for a bus. An old lady who looks like she's about to die. An old friend who once saved your life. Okay? The perfect man or woman you've been dreaming about. Which one would you choose to offer a ride to, knowing that there could be only one passenger in your car? So think about this. This is kind of an ethical issue. You got the old lady who's about to die, your best friend that has saved your life, and this person that you've dreamt about your whole life as being, you know, a wonderful partner. You could pick up the old lady because she's going to die, and that's kind of an easy one, and thus you would save her first. Or you could take the old friend because he once saved your life, and this would be a perfect chance to pay him back. Or you think about that beautiful person there, this could be the last chance you'll ever have to have that wonderful, perfect dream lover in your life. So here's what you do. You give the keys to your old friend, let him take the lady to the hospital, and stay behind and wait for the bus. Is that a good answer? I thought it was. That's called doing the ethical thing and thinking out of the box a little bit. And the thing that I want to emphasize about ethics as we go through them is this is an opportunity for you to do some thinking and to raise things up a little bit. The caption on this is the two men in prison. This is what happens when ethical standards are set artificially high. It's actually the opposite. We've just gone through this big phase in our country's history where we've had companies that have been basically taken from billion-dollar companies down to zero. We've had people get loans on houses they had no business getting loans on. And so you got to ask yourself, where are the ethics? You know, where do we start with these ethical issues? And it's all of us have to start saying we need to set our standards a little higher. And so that's why this applies to everyone. So which brings me to another question for you. And this has to do with water managers and accountants. These three water managers were traveling to Washington, D.C. on one of their junkets, and they're taking their accountants with them, three accountants. And so they're going to ride the train. So at the train stations, the three accountants bought 3 train tickets to get on the train. They watched the managers walk up there, and only one of the water managers gets a ticket. The accountants are saying, hey, wait a minute, there's 3 of you, only got 1 ticket. How's this going to work? How are the 3 of you going to ride on the train? And the water managers say, hey, just calm down, watch, you'll see. We can do this. So accountants are scratching their heads, They all get on the train, and accountants sit down, they're watching these water managers, and boom, all 3 water managers cram themselves into the restroom, and they close the door behind them. So shortly after that, the train takes off, and the conductor comes around collecting tickets. He knocks on the restroom door, ticket please. Here comes his hand out in the crack of the door, 1 ticket, takes a ticket, and they go. Door opened just a crack. Conductor takes it, and they keep going. The accountants see this, of course, and they thought that was a pretty clever idea. So after the conference is over, they're heading back. The accountants decide to copy the water managers on the return trip and save some money. So they're clever that way, So they go to the station, they buy a single ticket. To their astonishment, the water managers did not buy any tickets, not even 1. The accountants say, wait, how are you going to ride without a ticket? Water managers say, watch and you'll see. They get on the train. Sure enough, the 3 accountants go into one restroom, jam in there with their 1 ticket, and the 3 water managers go to the other restroom nearby. The train leaves the station. One of the water managers, gets out of the restroom, walks over to the other restroom, knocks on the door, and she says, ticket please. I thought that was pretty ethical for water managers. All right, I want to talk just a little bit about the evidence, the Nebraska Code. And this is a quiz for the lawyers. Okay, so the question is, what's the name of the body of ethical requirements which govern Nebraska lawyers? The Nebraska Code of Professional Responsibility, the Nebraska Canons of Attorney Ethics, or the Nebraska Rules of Professional Conduct? How many people say A? How many people say B? How many people say C? The C's have it. Okay? Now, why did I do this mean thing to the lawyers? It was fun. No. The reason I did that is because the Nebraska Code of Conduct has changed over the years. And why is that? One of the reasons is that the people who care about how lawyers are perceived in society generally want to have lawyers act better. And so what they decided to do was to change it. Now we have the Nebraska Rules of Professional Conduct. The reason they changed them is because of zeal. It comes in a jar now. Lawyers were zealous, and they were using their zeal to take advantage of people and do things they probably should not do, and to be very aggressive and to be overbearing and kind of mean people, got bad reputations, et cetera, et cetera. And so the people who did the code said, we need to tone things down just a little bit. We need to kind of remove the zeal issue, because lawyers would commonly say, I have an ethical obligation to zealously represent my clients. And so the people who monitor what lawyers do say, yeah, that's kind of getting carried away. And so they changed the code now to our current code. And the old code had a Canon 7, and the old Code of Professional Responsibility said, a lawyer should represent a client zealously within the bounds of the law. If you'll notice there, to this one canon, there was a table of contents, okay? And there's EC 7-39. Now that means there's ethical consideration 7-39. There were 39 ways you could zealously represent your client that you had to consider. And there were this many rules. There were, I think it was a total of 10 rules about how to zealously represent your client. It took 11 and a half pages for them to put this zealously, the rule concerning zealousness in the code that we had previous to the one we have. 2005, they changed it all. And the reason they changed it all is because sometimes lawyers were having a little trouble saying these three words. I don't know how to act zealously. And the trouble was the lawyers didn't know where the ethical boundaries were and often just stepped on them a lot. And so we saw a lot of cases where the lawyers were getting disciplined because they were over the top. And the reason I put this in there is because it's important for lawyers and for those who have ethical codes of conduct in their professions to be able to say, you know, I don't really know where my ethical obligations are, and go look it up. It's as important as knowing where 46.750 is in the statutes. I mean, you really need to know these things. You need to go look them up. And it doesn't ever hurt you to say to yourself or to others, and I don't know where that is. It's a hard thing to say, but it's an important starting point of everything. This right here is a copy of the statute books. And for those people from Washington, D.C., you know what we call these statute books? We call these the Red Books of Surprises. True? Lawyers, raise your hand. Is this true? Yes. I didn't know there was a law on that. But you go look it up. And the same way with the ethical code. You know, there is a code section on that. It's a little different now than it was before. And this is what I thought that people might want to say is, what do you mean, I'm supposed to know that? Yeah. Well, I can't be expected to have read every law book, he's saying to his client. Well, I think that it's the reverse now. You do have to know the ethical code, and you need to know it, and it's now called the Code of Conduct, and it's called the Rules of Professional Conduct. And I'm going to only focus on about 5 of them. I'm going to talk about competence, diligence, expediting litigation, candor, and fairness. I want to talk a little bit about the lawyer's multiple roles, and we've heard several people talk in the last couple days about what lawyers can do for people. And the legal profession looks at it a little bit differently. They say, well, you've got 3 different roles we want you to look at. Number 1, would you represent your clients? Okay, that's your first and primary role. That's one people most think lawyers do. They represent clients. Number 2, they're an officer of the legal system. You've heard the phrase, they're an officer of the court. And number 3, lawyers are public citizens that have a special responsibility to justice and to the system of justice, more so than other people because they've sworn to uphold the Constitution and everything else that they do when they get sworn in. So these 3 roles are really important, and I think the lawyers would tell you that these roles can cause problems for you in an ethical standpoint. Virtually all the difficult ethical problems that arise come from conflicts between the lawyer's responsibility to clients, to the legal system, and to their own interest in making a living. And the rules of professional conduct prescribe the way you resolve these rules. So knowing them is very important, and you do have to read every book that there is about it. Now, the thing that I want to highlight to you is that the new code of professional conduct as compared to the old code. The new code refers to zealous representation. How many times would you guess? Before we had 11 pages of it, how many times do you think we have reference to zealous representation now? 4. 4 times. 3 times in the preamble, and once in a comment to the rule on diligence. That's it. So we go from 11 and a half pages to 4. And why do you think that is? I think it's an effort to let lawyers know that it's time to start thinking more intently about these 3 roles that you have. The responsibility you have to your client, to the system, and to the overall status as an officer of the court. You need to look at those 3 roles, and don't look at it only through the prism or the lens of being a person that can be a zealous advocate. And I want to mention just a couple things to the lawyers because I think this is where the message comes home. You get in trouble if you're too zealous. And I'll give you some examples. I want to talk about one case in particular just because the facts are so weird, which they tend to be when lawyers get disciplined, but this is one of the better ones. This guy comes into this lawyer's office and says, I got this speeding ticket and this ticket for driving without a registration. I don't have, I just moved here, for crying out loud, and I got this failure to register ticket, and I just don't think it's fair. The lawyer says, well, let me take that, and of course my fee's $500 up front, but I should be able to get this taken care of, no problem. Okay, so the lawyer notices that the prosecuting attorney also has not yet registered his car. So he takes a picture of it, and he sends the picture to the prosecuting attorney and says, I'm sure you'll want to drop this case against my client, because if you don't, I'm going to ask for the appointment of a special prosecutor, and we'll see if you can't be prosecuted for the same crime that you're trying to get my client hung up on here and pay a big fine. And here's a copy of the motion I'm going to file if it doesn't get resolved quietly. And of course, once we're all done, quote unquote, puts in the lawyer, I'll just put this letter away and nobody will know the difference. All right. So the other attorney, the prosecuting attorney, says, you know what? It probably is a problem. I think I'll ask for the appointment of a special prosecutor. And so he calls the lawyer up and says he's going to do that. And the lawyer says, now, just a minute. You don't have to do that. This can all go away if you just drop the charges against my client. Well, the prosecuting attorney says, no. Ethically, I have to get a special prosecutor. So they do. The special prosecutor says, I have to call the Council on Discipline about this because this is an ethical violation. And so they do. The Council on Discipline for those non-lawyers is the guy with the big stick that works for the Supreme Court that says either you get to continue practicing law or you don't. And he comes around and he investigates these things and he charged the lawyer with the violation of the ethical canons. Supreme Court said here about 5 years ago, this indeed is an ethical violation. You cannot try to influence a public official by an improper means for an improper purpose. And so the lawyer got dinged on this. The odd thing is, instead of just going up there and saying, oh, I'm sorry, it was wrong, I should have done that, what does the lawyer do? Hey, just kidding. Literally, that's what he said. I was just joking around. The Supreme Court says, even that's an ethical violation. And so he dug his own hole. And he was suspended from practicing law. Another lawyer was suspended for filing irrelevant, abusive motions and pleadings in court. Another lawyer was suspended from submitting evasive and incomplete answers to discovery requests, which is kind of one of my favorites because I have a lot of those disputes. So what I wanted to talk to you about here is if you're going to get into the realm of not doing it right, you're going to have to pay the price. And so why not just do it right? The first rule I want to get into now is the rule of competence. A lawyer shall provide competent representation of a client, and that includes legal skill, knowledge, thoroughness, preparation, and judgment reasonably necessary for representation. And this includes knowledge of evidence, which I want to get into in just a few minutes about the knowledge of expert witnesses. And so I put this one in here. I can't be expected to have read every law book. Well, if you're going to practice in these specialized fields, you better be able to do that. And I think that comes down to, we heard some of these presentations here the other day, is you've got to keep abreast of the changes and what's going on. If you listen to all these regulations that are being put in place just throughout the whole state, and it's from the top to bottom, I mean the Supreme Court on down to the NRDs, is imposing all kinds of regulations on us and our clients, and on your clients. And so if you don't know those rules, I mean, I think it was Ms. Dan, we were talking about that, you get those rules out, you've got to study them. And if you don't understand them, there's somebody at the NRD you can call and ask about them. There's somebody at the department you can call and ask about them, but you've got to know those. And that's the basic rule of competence. The other thing that you have to do is you have to have the advanced knowledge if you're going to practice in a specialized area. And the Supreme Court recently, I think it was 5 years ago or so, had a situation where a lawyer was conducting work for a client but really had never practiced in that area. And because of that, the Supreme Court gave him a reprimand for that because he was outside of where he should have been in terms of his knowledge and experience and training. And what they said there was, if you're going to do that, you have to, at a minimum, do the necessary research to acquaint yourself with the breadth and scope of the law that your client is going to entangle themselves with if you're going to do that kind of work. The other thing I want to talk about, the next rule, is diligence. And the rule is a lawyer shall act with reasonable diligence and promptness in representing a client. And this is the one I put up here for this. There's a woman in the office there talking to the lawyer, and the lawyer's got his hands out and says, hey, don't blame me. I don't make the laws. I just circumvent them. Nowhere do I see this attitude displayed more often than in the person who can't get their discovery done on time. You give them 30 days, they come back and they ask for an automatic extension, you go, sure, I'll give you another 30 days. They come in another 30 days, what could possibly be causing you to need this much time? Well, there's 5 excuses. And I start thinking about the word circumvent. You know, are they doing this for some reason? They're just being less than diligent. So if you're going to take a case on, the message there is you've got to get going and get it done. The definition that I liked that I found when I was doing this work was a continual effort to accomplish something. An active attention to some matter in hand. In other words, a persistent effort. And so what I think of when I saw that was Sisyphus gets a desk job. Don't we all feel like this sometimes? You just, no matter how hard you push, that you're still going uphill. Well, there's no excuse. I mean, you accepted the work. You said you're going to do it, so you got to get it done. And what you've got to do is you've got to control your workload so you can handle things competently. That's the message. One last point I would make to you. Diligence, the duty to act with diligence does not require the use of offensive tactics or treat other persons with courtesy and respect. And this is something that suffers a lot when we get in the heat of battle sometimes, is this courtesy and respect thing. It's really important, no matter what, to respect that other person that's on the other side of the issue. It's just incredibly important. The Supreme Court defines diligence in a kind of funny way. Reasonable diligence, they use the word reasonable diligence, means appropriate action where there is some reason to awaken inquiry. I don't know why they would put the word awaken inquiry in there, because I'm thinking, what are you doing sleeping? You know, I mean, you should always be inquiring. That's your job as an attorney. In the context of an attorney who repeatedly failed to respond to discovery requests and court orders and failed to go to court, the Supreme Court defined the lack of diligence as a 30-day suspension from the practice of law. So there are consequences if you don't do your job. The next rule I want to talk about is meritorious claims and contentions. And this becomes a problem. Lawyers shall not bring or defend a proceeding or assert or controvert an issue unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. I think all of us have seen on TV, and some of us have seen happen more than once in a courtroom, where someone comes in and you spend a day on a hearing and you think, there was nothing to this. What was the defense all about? And the defense was all about was, well, they had one little tiny thing that they really thought was important that they thought we should litigate, and it turns out it was just absolutely ephemeral. There was nothing to it. That, to me, is not, in my view, a meritorious claim, and probably should have been taken out of court before it got to the court. But the thing that I want to show you this is the thing I thought was a good example. Would you look at this? Of course, he's walking down the steps towards his end place. Would you look at this? No handrails. Man, someone is just asking for a big fat lawsuit. And don't get me started on the heating system. Litigators have it. Obviously not a very meritorious claim if you're already there, right? The definitions of meritorious and frivolous are related. Meritorious claims are worthy of judicial inquiry because it raises a question of law deserving some investigation or a real controversy as to the essential facts. So there's a real question of law, or there's some controversy as to the facts. A frivolous action is one without rational argument based upon either the law or the evidence to support the litigant's position. And believe me, this comes up more than you expect, because the person who went through that long day trial without really a meritorious defense on the other side, what did they ask me to do when they got all done? They asserted a motion saying there's a frivolous defense and they wanted all their attorney's fees paid by the other side. And so we have to have another hearing on that, and we have a hearing on that, and then guess what? We have to have a hearing on the reasonableness of their fees. And so when I look back on that from a global standpoint, I thought, holy cow, that little frivolous defense cost me 3 days of time and it probably should have been settled by a quick payment of the money that was due. The next rule I want to talk about is expediting litigation. Again, you see the change in the thrust of the rules here. They went from 14 rules, or 10 rules on zealous representation, 11 and a half pages, to you've got to expedite litigation. Don't do this other stuff, but just get it done quick. Don't take the time that you don't need. So a lawyer shall not file a suit, assert a position, conduct a defense, delay litigation, or take other action on behalf of a client when the lawyer knows or when it is obvious that such action would serve merely to harass or maliciously injure someone. It is not proper to delay the expeditious resolution of a case if it's done for the purpose of frustrating an opponent's attempt to obtain rightful redress or repose. Let me read that again. It's not proper to delay the expeditious resolution of a case if such failure is done for the purpose of frustrating an opposing party's attempt to obtain rightful repose or redress. This sounds like the opposite of what you see on TV, isn't it? I mean, and that's often the opposite of what I see in court. Well, Your Honor, I know we brought this case, and it's a pretty much liability is admitted, and we're just looking at the damages, but we need a year and a half to figure out what the damages are. Are you kidding me? How could that be possible? They're all resolved. The crutches are off, and everybody's back to the. How could this? Well, we've got to depose every expert, every doctor this person's ever seen, and we've got to do. Wait, why? What's the reason behind this? Because you owe them money you don't want to pay for it? Is there really some question about the injuries? I mean, these types of cases we have make me think that there's some planning that went on ahead of time, which is illustrated by this cartoon. There's a huge group of people here, and the caption is, first of all, this meeting never happened. Now, what I took that to mean in this context that I'm offering it to you is, somebody somewhere along the line said, we need to string this out, is what I got in that message in that case. I just thought that was the wrong thing to do. This case should be resolved. The person got hurt, they should get their money, we should be done. And so when I hear things like that, I think, oh goodness, let's find out if there really is an issue. If there is one, let's get down to it. And so you ask the lawyers, well, gee, I can't really tell you, we haven't done discovery, we haven't done this. Well, I want to know if that's a tactic that you're using to delay it, or if this is the real thing. And so actions that are unethical in and of themselves are like where you lie about something, or you misstate a fact, or they're not inherently unethical, but they have the effect of causing delay. So technical and unnecessary defenses, refusals to answer discovery requests, waiting the full time to file pleadings, even though you're ready right away. And then the other thing that I see way too often, and some of the lawyers will tell you this is one of their most difficult things, you send out a set of interrogatories, and the answers you get back go something like this. This interrogatory is objected to because the answering party has not completed its review of the facts and will be answered in a supplement at a later time. What does that tell you? Zero, okay? But what was the question? Please produce all relevant information. So I've got a discovery request that says, please produce everything that could possibly be relevant, and I've got an answer saying, we don't know what that would be. And I've got the lawyers in court saying, I want sanctions because this is frivolous. Well, which is which? So what I would suggest to you is that responses to discovery requests that are vague, evasive, or indicate a lack of effort to ethically search for and find the relevant information are dilatory and should be avoided. I'm going to talk about one that's kind of near and dear to my heart, and one that lets us kind of get into the deal about the experts, where I want to spend most of our time. Candor towards the tribunal is one of the rules that you have, and that is, and this would extend to all tribunals. They didn't say courts here, if you notice. They said tribunals, and that means everybody. If your NRD board is sitting as a hearing body, the NRDs, the Department of Natural Resources districts, the Department of Natural Resources hearings when they have hearing officers, any court, obviously, but any other tribunal. A lawyer shall not knowingly make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact made to the tribunal by the lawyer. You shall not knowingly offer evidence that a lawyer knows to be false. You notice these rules talk in terms of shall not and shall instead of the other way around. With the old Code of Professional Responsibility, they made ethical considerations, things you were to consider. Well, the code we have now is more direct. more clear. You shall or shall not do this. Now, the way I illustrated this was, this is a Dilbert cartoon, and I'll read through the panels here for you. The first panel is, we'll lose the Elbonian project unless we give their minister of mud some incentive. You mean a bribe? No, a bribe would be illegal. Third panel, take a bag of gold to Elbonia and leave it by the statue of the monkey god Ubanabu. If Ubanabu does not accept your offering by Elbonian law, it becomes unclaimed property. Take the gold to the unclaimed property desk at the Ministry of Mud. Ring the bell and ask for the Minister of Mud. Give him the unclaimed property and a copy of our bid. The question, what if the monkey god accepts the gold and I'm the only witness? What? How much money, how much monkey god gold are we talking about? I thought this was just perfect here in terms of what are we trying to do here? We're trying to influence the Ministry of Mud, right? And how are we going to do that? We're going to give you some unclaimed property. And then the guy that's going to deliver the bag money, what's he say? Well, if the monkey god doesn't accept it and I'm the only witness, can I keep it? I thought this was like ethics within ethics. The idea here is that you're not going to convey to the tribunal the true facts or what's real about the case. Instead, you're going to use either a false statement or less than the whole statement to get the result you want. So you can't mislead the tribunal. You can't put in a situation where you use anything other than candor. And candor is defined by the rules as being openness and complete honesty. Complete honesty requires the whole truth and prohibits the disclosure of untruths or the omission of known facts. When to do so misleads or provides an incomplete disclosure. Now this rule catches you going in and catches you going out. And what I mean by that is if later you find out something was not true that was said during a trial or during a hearing or during a proceeding of some kind, you have an ethical obligation of going back in and saying, whoever your hearing officer is, what was said previously was not true. I must correct the record and tell you what the true facts are. So you get all done with your case and your witness says, you know, I misstated that. I didn't really see it happen that way. Ethically obligated, go back in and tell the prior fact, whoever that might be, this is what's happened. Even though the case is over, they're looking at it again, they're looking at it now to make the decision, you've got to let them know. And it trumps the duty of confidentiality, the duty of candor does for those lawyers there. If your client says in confidence, I didn't tell the truth on that, boom. Your duty of candor says, I'm sorry, you let me know, I got to go back and tell them you didn't tell the truth. That's a hard one for lawyers, but I think it's a very clear rule. The last rule that I want to talk about before we get into the expert witness is fairness to the opposing party and counsel. So when I looked at that, I thought, what's the F word here? And no, I'm not thinking of fatwa. I'm not going to say the word I'm thinking of, she says. She's carrying all these bags, and what are we looking for but the car, right? Fairness is the F word that I'm talking about, and lawyers shall not unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. Lawyers shall not assist or counsel another to do any such act. And what this is talking about in terms of fairness is most often you'll have some piece of evidence that's factual in nature. Let's say it's some study somebody's done of a groundwater movement or something. And you say, I've read this study, it was done by someone at the University of Nebraska, and I don't know if it's widely published, but I read it and it really kind of undermines our position on this. I wonder if I should say anything about it. And it's done by one of the leading experts on groundwater movement. What's the fairness thing? What's the fact? They did the study. Is it directly on point for what you're doing? Is it where you're working at? What's the fairness thing? You know about it? Should your opposing counsel know about it? Ethics say yes, you should. Let them know. All right, let's go down to the last part I want to talk about, which is experts. And when Mike and Professor Schetz asked me to do this, they said, you make this relevant to the water deal. And I thought, well, these water cases more and more and more are getting into the realm of high-level expert work. And the hydrologist, the geohydrologist, some of these groundwater models that you're working with are exceeding complex. I don't know if you've seen the one that the COHICE is working on. That model is it takes a huge computer just to run the thing. And the nodes they have established and the methods that they've established, how that water moves to the ground, it's phenomenal. It's very complex. And you need to have somebody like a Dwayne Woodward to tell you what it means, because it's pretty hard to figure it out yourself. And there aren't too many things in water law where you don't need someone to help you with some of these things. Especially, for example, when we're talking about what Jasper was talking about here in terms of what they were doing with their, I'm going to say this wrong, NCORP, is that the way you say it? NCORP? That's a kind of a complicated thing. Just to understand how it's supposed to work, where the water's going to go, who's going to get the benefits, how the benefits move from one to the other, and can you track all that stuff? That's complicated stuff. I mean, I imagine you saw some of that in your Kansas versus Nebraska case. Some of that stuff, some of the groundwater models, I don't know if you got to look at the huge boxes of evidence they had. Just to understand the math, you'd have to go through, probably differential equations if you went to college. And so experts are a big part of our lives. And I want to talk about them. First, I want to talk about what Nebraska law is now. Of course, we use the Dobbert standard. And we have a definition for experts because we have an evidence code. And the evidence code tells us under 702 that a witness is a person who has scientific, technical, or specialized knowledge and is qualified as that person. In other words, do they have that specialized scientific, technical, other knowledge? They don't have to have a doctorate degree. They just need to have that specialized scientific, technical, and specialized knowledge. And now, when you say to yourself, well, crying out loud, anybody could be an expert. I put something in your material that I thought was interesting. The expansive definition of an expert is nothing new. And there's a quote there from a case that was decided in 1859 by our United States Supreme Court. I'm sure this is one you've read, right? 1859? Okay. This is what they said. Experience has shown the court that opposite opinions of persons professing to be experts may be obtained to any amount. Okay? 1859 they were running into this, okay? We've been a country for less than 100 years. All right, so if you want to get expert evidence into the record in your court proceeding, there are 4 things you've got to do. You have to qualify the person as an expert. Then you have to determine whether their testimony is relevant. That's always a challenge. And then whether that testimony will assist the trier of fact. Will this prove something that will help the trier of fact make a decision? And whether the probative value of that testimony that you're going to receive is outweighed by the danger of unfair prejudice or other consideration. Those are the 4 things that judges look at when they're figuring out whether this evidence will come in. And it's controlled by those rules, not by the judge, because if they meet those rules, it's in. And then on top of that, we have the Dobbert Rule. And for those of you who may not be familiar with it, there was a decision made by the United States Supreme Court years ago, on the 1993, I think it was, that says that Dobbert standard shall apply to expert witness evidence. And what that requires is analysis by the judge as to whether this person's evidence has a high enough quality to be admitted in to be heard as evidence of the thing that they're saying it is. They decided that in 1993, and our Supreme Court quickly went and grabbed that decision and brought it to us. And when did they do that? In 2001, okay, a lot later, okay? The Dobbert decision says that you have to look at these things. Has the theory or technique been tested, number 1? Number 2, has it been subject to peer review and publication? That's a factor. Now, these are not inclusive. In other words, there's a whole bunch of other things you consider, but these are the main ones. Whether, in respect to a particular technique, there's a known or potential rate of error. Number 4, whether there are standards controlling the technique's operation, and whether the theory or technique enjoys general acceptance within the relevant scientific community. Then there's another nebulous factor that's involved, and that is whether the opinion can be applied to the facts at issue. That's what they call the fit test. And you look at that and you say, well, that's a great opinion, but how does that apply to what we're doing here? And the court's duty there is to look at those factors and decide whether this is good stuff or not good stuff. And this is where, we've heard this phrase, junk science. Well, this was a response to that. We've got to figure out some way to make sure we eliminate that. So we have the qualifications questions. So we got the TV newscaster, and this is so common. This is why people don't watch TV, including me. There's a newscaster. He says, "We now turn to an expert on this subject who doesn't actually know any more than we do, but he looks sincere, sounds convincing, and has a doctor in front of his name." Isn't that the truth, you know? People can say they're an expert, but you've got to qualify them. And that means, have they done the work that is pertinent to what they're going to profess they have some expertise in? Now, this is where I want to get into what lawyers should do, and this is part of the ethical code as far as I'm concerned. And it has to do with lawyers' role as officers of the court. Remember I told you the three roles they had? They represented clients, officers of the court, and then they're also responsible for society as a whole to make sure our system runs well. This is the second one of those two, that you've got to be an officer of the court. And this comes from our case law. An officer of the court has an obligation of both public and private. His public duty consists of his obligation to aid the administration of justice, his private duty to faithfully and honestly, conscientiously represent the interests of his client. And so you got two things going on here. And they're not in conflict if you'll satisfy the first obligation, which is to be an officer of the court. When you look at evidence, you've got to ask yourself, what rules apply? And I've already given it to you. Candor towards the tribunal, diligence, competence, those other rules. If you're doing a good job as an officer of the court, you'll make sure that you satisfy that obligation. Especially when it comes to candor towards the tribunal. Now this rule, I think, different from the prior code of professional responsibilities, really outlines the duties of lawyers as officers of the court. And you can't do any kind of conduct that undermines the integrity of the adjudicative process. If you're doing something in that hearing room or in there that you just don't think is the right thing to do, you need to stop. I mean, that's not what you're supposed to do. If this evidence is not good, if it's not quality, if it's not really supported by the science or the facts, you shouldn't be putting it out there. And I'll give you an example, not to pick on anyone, but the Gateway Parks Commission got an in-stream flow on the Platte River. Where's Mike Jess? Is he still here? You know why he left? Because he knew I was going to tell this story. And so they asked for flows in the Platte River like 1,200 or 1,500 CFS in the summertime. And Leroy Sievers probably will remember this too. And so everybody looked at that and said, what? In the summertime? Platte River's dry in the summertime. Once in a while it'll flow at Grand Island, but it's mostly dry. Well, this was a 1,500 CFS flow all the way from Lexington, I think, all the way to Chapman or Columbus, a confluence of the Loop or something. And so those of us who thought this was way too much water and that would preclude the use of any water out of the Platte River for as long as the in-stream flow right was there, said, we need to challenge that right. And so we said, what is it based on? We sent some discovery stuff to the game parks, and they came back and they said, well, we need to establish habitat for the forage fish for, I think it was plovers, okay? The plovers are, at this time, piping plovers are endangered species, and we need to protect those fish. And we're also worried about fish kills. Fish kills. You mean like catching fish? Oh, no. We're talking about fish kills. Well, this nebulous fish kill thing, what would that be? And so we thought, well, there's some scientists that will define fish kills for us. So we go and we take more discovery in Game Parks Commission, and we finally say, well, is there some kind of process by which you decide that when you see dead fish in the Platte River, it's because there's not enough water there? And they said, well, we just look, and if they're laying there on the dry ground and they're dead, that's a fish kill. Okay, seriously, that was about it. So I said, well, do you keep track of this data? How do you know that you need 1,500 CFS? Why isn't it 300? You know, how do you know this? Well, we keep a file. Oh, let me see the file. So I get this file, and it's a paper file. This is back in the old days. We still had paper. And in there is just this, on the manila folder is listed this list of fish kill events. So they're just listed there, written down. And then there's just this sheaf of papers with like, Betty Johnson from Columbus called up, and she saw a dead fish in the Platte River today, and that gets written down. And then, newspaper accounts, they're in there, and, so-and-so drove over the bridge at Columbus and saw a bunch of dead fish. Well, it's written down. And so I deposed the person who's in charge of fish kill evidence, and I said, what's your scientific basis for your fish kill number? Well, just look at this file. And I said, I have looked at this file. I said, the question remains, what is the basis for it? Well, look right here. And I said, well, pull one out. So he pulls one out, and it happened to be a story of a gar. You know what a gar is? They're about as ugly a fish as you want to get, okay? And they're not little. okay? They're big. This gar was laying on a sandbar in the Platte River, and it's dead. I said, that's a dead fish, you know? The guy says, yeah, that's one of our fish kills. I said, is that where you got the fish? Well, yeah, because at the time that fish was found there, we measured the flow in the river, and it was less than 1,500 CFS. And I said, so because the flow went down, that fish died. That's right. I said, so you're telling me for all the gars in the Platte River, they need to have 1,500 CFS? That's right. I was stunned. And I thought to myself, they aren't going to bring this into court. They're not going to come before the august body of the Department of Natural Resources and say that this with a straight face. Oh, yes, they did. I think that was the longest day in that life, the life of that witness, when we sat down and said, okay, now let's talk about your whole fish kill thing. And why do I bring that up? Is just, I thought to myself, where's the science here? Where is the science? I mean, if you're going to say that this thing occurred, and the reason it occurred is because the flow in the Platte River had to be this high instead of this high, you need to explain that to me. How could that be? Because it was observed at that time, and at that time we looked in the book and it was less than 1,500 CFS. That was it. Well, I thought that in myself, I thought that was a very little persuasive force. And I was able to convince the director of the Natural Resource District, along with all of our other witnesses that we had, that that was indeed the fact, because they did not get their in-stream flow for that amount. Now, I want to talk about meritorious claims in that as a lead-in. That is a lead-in to that. So we now got the Dobbert standard. We didn't have it back during the in-stream flow days. So now that we've got it, what's a lawyer's duty? If your client comes to you with this fish kill file and says, I want a 1,500 CFS flow in the Platte River because fish are dying, would you not want to say something like, well, we need more than just a file of newspaper clippings? You would. And so what is your duty? Does it go beyond, once you start thinking ethically and your duty to the tribunal, what's your duty here to do that? And there are some commentators that have suggested some things that I want to run these by you real quickly to see if you agree. But before we do that, let's take a commercial break. This happens, okay? This truly happens. There's a judge sitting up there, and the judge has got this little bubble up in his head, and he's thinking, how did this case ever get this far? And the lawyer down here with his tie and coat on, and he's thinking, why did I ever agree to try this thing? And the witness is sitting there, and the witness is saying, boy, this is neat. When I saw that, I thought of fish kills. Just, well. And the thought that I had was, what would the lawyer, why did the lawyer get it that far? Why did I ever agree to try this thing? And where's the lawyer at? Well, take that Dobbert standard out and apply it. Talk to your client. Say, now, just a minute. We're going to have to meet this evidentiary standard here. Can we do that with what we've got? And if you can't, then you need to tell your client, we need to throw this away and start over. We just don't have it. And I think of some of the stuff you've seen the last couple of days. They've got the data. They're collecting the data. Now, the opinions, conclusions you might argue with some, but at least they're collecting the data, and they're doing it in a scientific, measured way with an effort being made to apply science. And that's what you want to do. And as a lawyer, I think you need to direct those people to say, hey, we need to know the Dobbert standard. You, as my expert witness or your technician, whatever it might be, you need to know the Dobbert Rule so we can apply them. Is this been peer reviewed? Is this a method that's commonly used in the field? Have others used it the way that you're using it? On and on and on. So I think what you want to try to do here, if you're a lawyer, is to have some sense of your responsibility as an officer of the court to make sure that the evidence is quality and not false and not a stretch. So here's some suggestions. There's no case that says this. I looked and looked and looked and couldn't find a case for this. But there's a lot of commentators. And, this is the funny thing. How many professors do we have in here? How many? Just one? Are you by yourself? I don't feel like picking on just one of you, okay? When you read things like law review articles, the people who write law review articles always are looking for case law so they can say this is where the law is going and that type of thing. But when the law is not going anywhere, then they cite each other. And they'll say, as another commentator said, and then they'll say this. And of course, then that commentator then will say what the other commentator said, and so there's this mutual, validation going on back and forth. I found a lot of this validation for this, so I feel good about bringing this up to you, okay? And this is something that, it's not in the rules, so it's not a case decision, but I want to bring these rules up to you. And this is what people have commented on. Number one, if you're a lawyer and you're familiar with the concepts of reliability and validity, okay? Reliability and validity are kind of the touchstones of scientific work, okay? Is it reliable? Is it valid? You know, do we follow valid methods? Is the data consistent with our methods? You know, that type of thing. Then you need to say, okay, is this genuine and reasonable? Are you really doing this work? You've got to tear your expert up a little bit. And of course, when you're working in some of these experts, you barely know what they're talking about. Okay, let's be honest. I mean, when you were reading through some of that Kansas v. Nebraska stuff, you thought, what in the blue blazes are they talking about, right? And sometimes when you're doing some of your work, and I'm sure that some of the lawyers would raise their hand reluctantly, but they would say, you know, I kind of know what they're talking about, but they were blowing smoke so much I couldn't hardly tell. You've got to know this. You've got to say, okay, where is the soft underbelly of this thing? Where can I go in here and find out what they're doing? And I think the commentators would tell you that this is what's going to preserve our system and give legitimacy to it, is if you're a lawyer, do not ignore your doubts or the questions you have regarding the validity or reliability of your expert's evidence, where you, after reasonable and diligent inquiry, could confirm either the lack of scientific validity or rigor or the falsity of the analysis or opinions. That's your job. You can't just say, well, you're the expert, we're just going to throw it at the wall and see if it sticks. Believe me, people do this, okay? It happens. So I think lawyers have an ethical duty to reassess the reliability, validity, integrity, and relevance of the expert's evidence, okay? You've got to go after it. And, you know, your expert might be saying, they're paying me to have you tell me what I think, and you're just putting them basically through their own cross-examination. But it's far from just being a good lawyer prepared for the tribunal. You're doing that because you want to protect the tribunal from this evidence that may be questionable. All right, let me roll over to two other things I want to bring up before we get here. This is another. This guy's sitting on the phone. I know nothing about the subject, but I'm happy to give you my expert opinion. That would be the first warning sign, okay? You need to check their credentials, is what this cartoon illustrates. Checking the credentials means, do you really have the things that you say you do? You know, you've got a degree, and it's a PhD in hydrology. Well, what did you do to get that? Did you have a thesis? What did you write your thesis on? What was it about? Was it, you know, did you get challenged? Did you have to defend your thesis? The whole deal. You want to kind of put them through it. Because if the lawyer on the other side is any good, they'll know all that, and they'll either make your expert a better expert, or they'll tell them apart. So you need to do that anyway. The second thing is, you must pursue a reasonable and diligent inquiry that will resolve all your doubts and questions. Even if you feel like, geez, I'm getting paid by my client, I don't really know what they're talking about here, I really need to dig into this. Well, don't be deterred. Get after that expert and ask them those questions. And if you've got to educate yourself on it, you have to educate yourself on it. I mean, how many lawyers in here went through law school and were worried about Darcy's Law? Okay? Raise your hand. How many of you heard of Darcy's Law before you got into water law? None of you, okay? Well, maybe. Did you know what it meant? Goodness, no. Until you got in there, you thought, I better learn what this Darcy's Law is. Because otherwise, you're going to get snowed. I mean, that's the whole idea. If you're going to take on this work, you need to know what you're doing. Now, the other thing that I want to end up with on this deal is, before I get into one last thing, and that is, if your expert's going to testify in an area that's not scientifically valid, okay? We have this tomato grower in Dawson County, and he has a glass building, a huge glass building, almost as big as this law school area here, bigger. Glass. What is one of the enemies of glass? Hail. And what happens in the hot summer nights in Dawson County? It hails like hell, okay? I mean, it just comes down in the big like this, you know, like go through your roof. And so the guy, after he gets done building this, says, oh, shoot, what if it hails? Well, he hires this guy who builds what he calls a hail cannon. You ever heard of a hail cannon? I have. I spent a day listening to this guy trying to convince me that a hail cannon had some scientific validity. You take this big thing, and it looked like a great big huge howitzer, basically. He fills it up with this flammable, combustible thing, pulls the trigger off it, and this thing goes most incredibly loud kaboom. And the idea was that kaboom would send the shock waves into the clouds that were coming right towards this guy's, and part the clouds somehow. And so the hail would go around. And the guy says, well, we have to do this. Well, the people who lived around them said, it's bad enough with the thunder and lightning, but this dang cannon's going off. It's shaking the windows in our house. And we want you to stop it. It's a nuisance. And he goes, oh, no, we do it for scientific reasons. I said, what? And of course, the lawyers just kind of threw this at me, hoping that I would believe it. And I said, wait. I said, has anybody ever studied this? Well, not that I know of. Is there some kind of peer review for something like that? Not that I know of. Has this been tested to be determined reliable? Well, not that I know of. So, well, why would you give this to me then? I can't make a decision based upon that. I thought that was perfect for having an expert in an area that's not scientifically valid. Last subject, and we'll go. The side switching expert. This is a case for Nebraska. And beware of this, lawyers and water managers and other people working in water. This case is in the material. The name of the case is Mid-America Ag Products Horizon LLC versus Rollins, Judge Rollins. 286 Nebraska 305, 2013 case. Long story. I'll shorten it and tell you in 2 minutes. Expert over here on forward corn contracts, okay? He is an expert in forward corn contracts. He knows that the National Grain and Feed Association had these rules about how you do forward grain corn contracts, okay? He's an expert on it. Everybody agrees he is. So the defense lawyer calls him up and says, hey, could you work for us? The guy's name O'Neill. He goes, well, I don't know. What's in the case? He goes, well, it's X versus Y. Well, I've kind of done some work for X a couple times, but hey, tell me what you got going on. So he tells him. He says, I think it'd probably help you, but I'd have to check out, I may have done some work for a subsidiary or a related company or something. But anyway, tell me what's going on. So he tells him. And so O'Neill says, well, you know what I'm thinking, this might solve your problem. And he tells him some stuff. And then the guy sends him a bill, which the lawyer pays. Who shows up on the expert witness list for the other team? O'Neill. And he writes an opinion saying the opposite of what he said over here. This contracts are illegal, is what he says. And so the lawyer talked to him first, said, now wait a minute. I called him up and told him all this stuff, and now hey, this can't work. This can't work. I want to disqualify him and the law firm that hired him. Judge Rollins said, the expert's out, but the lawyers, there's no evidence that they got wind of what the other lawyer told him, so we're not going to kick the lawyers out. The Supreme Court said, definitely the expert's out. And the lawyers are lucky they didn't get kicked out, because if they could have shown, the defense lawyers could have shown that the plaintiff's lawyers had knowledge of what the defense lawyers said, they'd be out too. So beware of the side-switching expert. That's what the Supreme Court called them, a side-switching expert. All right, it's 4 o'clock. I'm done. Thanks for coming.